Justice Watchers, before we begin, I want to make this absolutely clear. The following broadcast contains public domain courtroom footage, commentary, and legal analysis. This content is presented under the fair use doctrine as defined by 17 USC 107 and is protected by multiple Supreme Court rulings, which you see below. This stream is transformative, educational, and journalistic in nature. It includes original commentary, trial breakdowns, legal interpretation, and critical analysis, not raw redistribution. We do not claim ownership over any public domain footage, and all use is strictly within legal bounds. If you're watching this content, you're engaging in a protected, transformative experience, grounded in law, never in speculation. And if anyone has a problem with that, take it up with Campbell, Brady, Miranda, and Irvin. Remember, guys, justice always works better when we watch. So keep watching. See you in the courtroom.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannoni, the Justice of the Superior Court, now holding in Dedham within and for the County of Norfolk. Draw near, give your presence, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
All right. Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors. Good morning. So I have to ask you those same 3 questions before we send you back out to deliberate. Was everyone able to follow the instructions and refrain from discussing this case with anyone since we left yesterday?
Yes.
Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or shook their heads. Well, with that, Mr. Foreman, thank you all. We're going to send you back out to deliberate.
All rise, please. Here, follow me. Jurors exit the courtroom, please be seated.
All right, counsel, I think it worked out well having everybody planning on being here at 4 o'clock and being no more than 10 minutes away. So we'll see you here a little bit before 4 this afternoon.
Thank you.
All rise. Court stands at recess, please exit the courtroom.
Guy.
Give her some room, guys. Give her some room. Give her some room. Not gonna be a
today,
comment,
guys.
guys.
Excuse us.
Okay.
No comments while
Do
the
you have any
jury's
thoughts,
out.
William?
Thank you all so much.
You look well. Yeah. See you later on, okay?
Good luck.
Back up.
Have the manager. Agree down.
I don't like
Hello, hello, hello. Thought I'd stop in real quick, especially with the jury deliberating, and kind of weigh in a little bit on my thoughts on what Judge Cannoni's doing. And I thought maybe we would address some comments here on the whole situation that happened yesterday, and have a little discussion, because I think that if the defense is not careful, they're going to be going down the same road that they were last year. Now, I think they're trying to be more careful, but I think that, they need to let Alan Jackson work his magic. We need to make sure that Alessi, if he needs to step up, whoever needs to step up needs to make sure that if this jury were to come back and report that they're deadlocked, that they make sure that the jury is polled. Because what Cannoni's doing right now, let's be clear on it, is she realizes that this jury, in all likelihood, has acquitted Karen Reed of the two most serious charges. And what she's trying to do is prevent them from coming back and announcing that, and giving the Commonwealth yet a third shot, which the hot mic moment yesterday from Alan Jackson indicated that he said, I don't want to do this again. And again, the more a case is retried, the worse it is for the defendant, the more times the Commonwealth gets to adjust their case, and of course, the financial toll it takes on the defendant. So Cannoni knows this, and she doesn't want to let this case have a verdict on the two most serious charges, because it's going to make it less likely that it looks like it would be financially viable for the Commonwealth to keep pursuing this when they lost the case on the top two charges. And potentially, if the jury is allowed to speak, they may even say, listen, we've acquitted her of everything but OWI, and that's where we were hung. And then, again, without them being able to, again, there's a method to her madness. It would then become a matter of litigation after the fact as to whether or not the jury, if they announced in court, hey, we've acquitted her of everything else, the only thing we were hung on is OWI, then technically speaking, she's been acquitted. Now, of course, that jury form, this is where the jury form comes into effect. The lack of not guilties on all of those other charges, which is why she doesn't have the not guilties on there, because what she doesn't want, the worst case scenario for the Commonwealth, is that not guilty, not guilty, not guilty, not guilty, hung on OWI. Therefore, all they're left then with is a OWI charge. Now, I want everyone to understand this. The state of Massachusetts is the most aggressive state in the United States in process for DUI charges. So I want you to understand that Karen Reed faces up to 2.5 years if she's convicted on that charge. Rest assured, given the fact that a death is associated with this case, if she is convicted of that charge, I believe Bev Cannoni will absolutely revoke her bond and put her in jail pending sentencing. So any conviction, she's going to go to jail, because she's facing up to 2.5 years. Now, first offense, the typical way this gets worked out is probation, and they get to take a class, and that's the normal situation. I don't believe Bev will handle it that way. If Karen Reed gets convicted, she's going to get taken out of the courtroom in handcuffs. Bev Cannoni is going to give her 2.5 years. It will then become a matter of appeal and go under appellate review, which of course will mean she's going to spend some time in the House of Corrections while she's awaiting the appellate review. Now, it's possible that she gets a bond once she files, because it will be unheard of for a first offense OWI to get that stiff of a sentence. But I believe Cannoni's going to do it. I mean, I think that any conviction whatsoever, she's going to do it. Now, it will look so egregious to everyone if she does do this, because of the disparity between how these cases are normally handled and how it's going to be handled for Karen Reed. But I believe firmly, if she's convicted of anything, she's going away because of the law allows it. It's punishable up to 2.5 years in prison in the state of Massachusetts. So if you're ever in the state of Massachusetts, do not drive drunk. Okay, it's the worst state to get caught in. So, but I don't think Bev Canoni wants that type of victory. I think she wants to see, again, if they're not going to be able, if she's got any way she can tie this up, she's going to do it. And that's what she's trying to do. Because here's how I see this unfolding. Right now, the way the jury phrased this, and this is what she was hinting at, is it's theoretical. In other words, they asked a question. If we were to find her not guilty of 2 charges and we're hung on the 3rd charge. Now, her goal is she doesn't want them to state, and that's why Alan Jackson was pushing and saying, hey, we need to let the jury know that this is a theoretical situation. So if this is actually happening, let us know and then we can deal with it. She didn't want that language to go back to them, and it's not back there to them. So they're back there with this thinking, okay, well, I guess we're going to have to figure it out on our own. We don't know. I guess we're going to have to keep deliberating. And what she knows is the jury's probably going to assume the worst. They're going to assume that, well, I guess it would be a hung. We got to keep working on this and we got to figure this out. Of course, juries are funny things. You can literally have the jury might be in agreement right now. Hey, not guilty on 2 charges. And then on the 3rd charge, they're hung. And all of a sudden you come back in today and now it starts to swing back the other direction. People sleep on it. People start to discuss it more. And the more this gets discussed, the more suddenly people start to swing back and forth. And she knows that. And then, of course, if things go the way she probably would prefer it to go, if it's not going to go for a full conviction here, what she's hoping is this jury's going to come out and say we're deadlocked. Once she does that, rest assured she's going to say, okay, court's adjourned, take the jurors out, get them out. We have a security issue. We need to make sure the jurors are secured. The defense is going to be standing there in the courtroom saying, Your Honor, we want the jury polled. She's going to adjourn court and they're going to go. What's going to happen then is we're not going to know. We're going to be in the same position that they were in last year. Because if that jury is not polled in that courtroom, after that, it will be a matter of whether or not she allows for the jurors to be brought back in. And then we're literally right back to replaying this whole situation. And the appellate courts can say, well, we don't know. Now, in this case, the defense, if the defense makes the formal request, if they're able to get it in, and I'm sure they will attempt to, and if she's blatantly going to have, she's going to have to deal with it, it's going to be a little different this time. But the bottom line is if the jury never speaks, if the breakdown is never known, and if you can't get all 12 jurors in the room to confirm what was going on in that room, then again, you're probably going to have the same result as far as the appellate courts go. They're going to say, well, the state gets to retry the whole case again. And again, it's disastrous for the defense because Karen Reed has to pay for these defense attorneys. These defense attorneys, as of right now, are not being paid anything. And again, for them to continue to go 2, 3, 4 years where this is the only case, they're getting paid nothing. Financially, it puts them in a terrible bind. And they know this. And then they can go pay Hank Brennan another $350,000 to come retry the case. And this time, Hank is going to, again, make adjustments. They're not going to have the ability to go and argue to the jury, hey, they made their change in the middle of the trial. They're going to have their experts ready. Now, will they be able to cross-examine them? Yes. But, as you saw with this case, Bev Canoni, as long as she's allowed on the case, will be a gatekeeper. Now, what we could hope is in the 3rd trial, potentially she gets tossed off the case, depending on what she does as this jury comes back. And she tries to get in the way of polling the jury and finding out if they've come to a verdict on the other 2 counts, since as of right now, it appears they have, and any judge doing their due diligence, and any judge acting in good faith of making sure that Karen Reed's due process rights are protected would want to do that. But I think we know that Bev Canoni doesn't have Karen Reed's due process rights in mind as she's operating right now. And for her, she's got the Commonwealth and Prosecutor Morrissey, because remember, she was a prosecutor in that office. Her allegiance is not to fairness and equality and justice. And you can see that in how she's acting. And I understand there's people out there on the idea that Karen Reed is guilty, and they think that, oh, the free Karen Reed people are conspiracy theorists. They're not. It's the proof is in the pudding right in front of us. If this judge is acting fair, don't be afraid of the truth. Don't be afraid of what the jury's trying to tell you. This jury's been working hard. Let the jury speak. And the question is, why doesn't Bev want the jury to speak? And that is a question that needs to be answered. It needs to be addressed. And I think it's going to be much more difficult for her to get away with some of the things that with completely doing things the way they were last time. But listen, the defense has to be very, very, very careful. Very, very careful. Because I have a feeling that she's going to be trying to move fast on this. And if they're not careful, they're going to end up right where they were before, or last year, I guess you could say. And that's a disaster for Karen Reed, because for her, she doesn't have unlimited money like the state of Massachusetts or the Commonwealth of Massachusetts. And that's the downside. And the idea in the justice system is that, well, excuse me there, guys, I apologize. We're going to go through some comments here in a second. The idea here is that the burden of proof, or the burden of proof on the state, and the presumption of innocence is supposed to be the evening factor. But we all know that's not true. We all know that the state, or Commonwealth in this case, who has all of these resources, who has unlimited resources, who can continue trying a case over and over and over again. It's the one gap in our system that is completely unfair. And that is that the cost and burden of a mistrial falls squarely on the shoulders of the defendant. And I have always said that the burden of proof and the presumption of innocence is not enough to really truly even the playing field. The defendant, and again, if we want to do this fairly, the defendant should have an equal budget to the state, and they should be able to hire private counsel. The only right way to do this is you give a budget, which of course while also, so the budget should be given to the defendant to hire outside counsel. You should be allowed to hire counsel commensurate with what the state is spending. They should be able to get experts commensurate with what the state's experts are costing. They should be able to have access to everything that the state has. And in my opinion, also, if they want to be able to use their own personal resources and add to that, they should also be able to do that. That is a fair system at work. And anybody that thinks that's not fair, listen, I disagree with you, because that's the only way for it to be fair. And then you add in the presumption of innocence, and you add in the burden of proof, and then you have a system that truly operates in fairness, and we would be able to trust the outcomes of that system. Now, a system that says, no, you're going to have to hire a public defender who's overpriced or who's overworked, whose caseload and case burden is through the roof, that's troublesome. Because to me, the ability to hire your own counsel should be something that the defendant is able to do with, again, a budget that is provided by the state who's bringing these charges. In that way, they can go find an attorney of their liking, bring that person in. And again, if they want to add, or if they need to add money from their own personal resources, that's something that they can work out. But to me, anything short of that puts absolutely puts an unfair burden on the defendant, especially in cases like this where there's a potential mistrial and you're looking at a third trial. You're looking at experts that have to show up again and testify. Nobody's going to be able to do this work for free. These attorneys can't work for free. And, it's a disaster. It's a disaster for Karen Reed if this ends up in a mistrial. And that's why, of course, that's why you saw Alan Jackson very frustrated. His face is red. He's pissed off. He's angry. He's mad. And that's just where it is. So, all right, let's look at some comments here. We're going to get into them. All right. So first comment that we're going to get to. Give me a moment here. All right. So first off, we have Tony K 6162. We're going to just go right from the top here. Hank Brennan did an outstanding job. At the end of the day, the jurors are from this small town, and small towns are going to stick together. Well, Tony. I think Hank Brennan did a good job because he's a defense attorney. He did a good job trying to win a case. Let's be clear on that. Now, this is where we disagree and where we're going to diverge. He did a good job trying to win a case that he should have looked at and said, this shouldn't be prosecuted. Not with the evidence the way it is, not with if he's looking through this from the lens of a defense attorney, which is how he should have been looking at this, his recommendation should be, we drop the charges, because there's no way that you can put this case before a jury and do it honestly without messing around with experts, without asking your expert to read your reports in the middle of a trial and say that there's proof beyond a reasonable doubt that Karen Reed is the cause of John O'Keefe's death. There's just no way. And no individual who's understanding how the law is supposed to be applied and applies it to this case can do that. They just can't. It's impossible with the evidence that they have. The only way you win this case is if you do what Hank Brennan's really skilled at doing. That's twisting, turning, and doing what you saw. And yes, it was a masterful performance. I talked about that. The way he tried to take that 28 minutes and say, look, what did she do during this time? Oh, she must have went. Because look, even the flip side to that 28 minutes is she could have very well went and discovered his body. It doesn't mean she hit him. It just means she knew he was there, and then she panics and thinks, oh my God, did I hit him? In fact, if she would have admitted to that, it would actually explain a lot of what she was doing and what she was saying. And from a strategic standpoint, it might have been smart to have said, but of course she'd have to testify. For her to have said, yeah, I drove back by 34 Fairview. I got out of the car. I'm looking. I'm seeing if he's there, and I found him. Now, the problem is, of course, is that she doesn't call 911. And she doesn't call 911 because she shouldn't call 911 because she panics and freaks out. She's intoxicated, number one. Still, we know she was intoxicated because when she took her blood test at the hospital, she still was. And two, she's thinking to herself, oh my God, did I do this? And then she goes into cover-up mode. Doesn't mean she actually hit him. It just means that she thought she could have, and she didn't handle it right. Now, again, does that look good for the jury? Again, it's not the most opportune, but it could explain a lot of her behavior and a lot of the things that people found suspicious. Does not equate the meaning that she hit him. It just means that she fell for the trap that the Alperts set out for, if they in fact were, if Higgins and Alpert were responsible for John O'Keefe's death, which I don't believe can be ruled out. You have experts who've come in and said the wounds on his hand or on his arm could have been dog bites. Again, I also say and I didn't hear this argued, but to me, I don't understand why it wasn't. Look, by the state's own experts, they put the phone in John O'Keefe's hand. You've got expert testimony that says if he is hit by that car at 27 miles an hour, he's getting broken bones. It's going to do damage. So how does his cell phone end up underneath him? No one's explained that to me. Because if he gets hit, that cell phone's flying. And the cell phone ending up underneath him is a tell, in my opinion. And it's the biggest tell that this was a staged crime scene. And I'm very surprised that the defense and no one made that a point. Because to me, what that tells you is that someone was aware of all the phone calls John was getting. And someone felt the need to explain away why those phone calls. And again, I remember Jeff Pogue was in there. My good buddy Jeff Pogue was in. And he was saying, well, this nobody would have heard it because it was so far away. I don't agree with that. You have a night where there's no cars coming down the road. Go outside in your neighborhood. Put your cell phone outside. Put it in the middle of your yard. Okay? Ringer on. And start calling. And you tell me if that's not going to be echoing through a silent neighborhood in the middle of the night. In 52 phone calls. Go ahead and call it 52 times and see if somebody doesn't pay attention to it. If somebody doesn't hear it. And they knew she was calling like a wild woman. And that's why they put the phone underneath him. Because the only way you explain why the phone wouldn't have been heard is if it's muffled by laying underneath his body, which is inexplainable on how the phone, he gets hit at 27 miles an hour. The phone should have went flying and he goes down. And just like the glass allegedly went flying, how does the phone survive that? And it has no damage. If a hand's getting broken, a phone's getting broken. If you're getting a break in the taillight with a collision to the degree that it breaks, that it broke all the way down to the internals, that phone's not surviving that. But again, I think the defense must have felt, hey, there's other points. But to me, that was a major point. The phone that everybody's relying on and saying, wow. Not to mention that, guess what? Guess what's also missing? The phone is the key. Because if a collision happened, okay, the iPhone should have recorded the collision in the hit on the ground. It should have recorded it. Remember the Murdoch case when he threw it out of the car and they made a big deal and they could tell that the phone was flying because of the accelerometer, because it landed. Why, at the same time, doesn't the phone log the fall of a 27-mile-an-hour collision? Why is that not being logged? Why is that not being recorded? Why is that nowhere in the data of the phone? It's missing. Again, that tells you everything you need to know. It's missing. Should have been argued to the jury, along with everything else. The phone is the key because it's not doing what the state needs it to do if he's being collided with out in front of 34 Fairview. No one has shown any accelerometer data, which should be present in the phone, if that phone is flying through the air. And it would be flying through the air, whether it's flying through the air behind John O'Keefe or flying through the air landing on the ground where John O'Keefe lands in front of it. Regardless, it came out of his pocket. The state says it was in his hand. Where's the data to support that? You can't have it both ways. And the defense, of course, says, well, they focused on the steps, but they didn't focus on what it didn't do. And maybe there's a reason for it. I don't know. Maybe there's something deeper in the data. Maybe, whatever. But maybe they felt the dog bites and everything else was strong enough. But to me, you couple that in with the dog bites. You couple that in with the video of Higgins. You couple that in with Higgins' ominous text. You couple that in, and you put it all together. And now Hank Brennan is having to explain that. It's not explainable. That jury, if all that goes back there, no, jurors may be looking at all that. But to me, that is key. All right, so let's look at another comment here. All right, so Pamergan says, I want Canone and all these other criminals to face the same biased and unfair system Karen has faced. Each page and each number of those charges ought to have a line which says not guilty. I agree 100%. Like I said, there's a reason for it. The confusing verdict slip is meant so that they can't have her acquitted on those other charges. And if the jury deadlocks, then they don't have a record of what they deadlocked on, and they can go back and try her again on the entire charge. That's why they don't do it now, And according to, again, Massachusetts law does not require that. Something that the legislature should take up. Making something deliberately confusing, which could result in person serving a life in prison, is wrong. Prayerfully, this jury will check not guilty on everything and move on, whether they believe she was driving under an influence or not. She already paid one of the biggest fines in history for possibly drinking and driving. Eddie Paul says, now that's cleared up, I bet they come back not guilty on all charges very quickly. Aunt Beveridge is deliberately sabotaging this trial, says Anthony Johnson. Judy says, okay, Miss Piggy's Aunt Bev has spoken. Okay. Easter Meering says, can this judge not be reported? All right. So let's talk about a few of these comments. A couple things. First of all, the judge can absolutely be reported. And, the problem is, it's difficult to get someone to pay attention to things like that or to things like this because they have to prove. Now, again, she's kind of in a position right now where, depending how desperate she is to try to get this case, to try to avoid these verdicts coming in on the other two charges, she may step over the line. And I think that's what the defense is hoping that she's going to do. And I do believe that defense is going to say, it's going to scream at the top of their lungs that this jury needs to be polled if she tries any funny business. But I think she's going to try. She's already tried. And she's going to try to rely on the fact that if the jury isn't willing to speak about what happened in that room, if they don't make it abundantly clear that a verdict's been reached, then breaking into the province of the jury room is just not something you're allowed to do. And she's not going to allow it to happen. And she's going to dismiss those jurors. And again, Yannetti let that happen before. Jackson let it happen before. But I think Jackson definitely says, I don't want to do this again. I can't afford to do this again. He's got a law practice out in California, and he's losing money by the minute being out here in Boston on a case that he's making no money on. But for him, this has become an ego thing. This has become a situation where he's determined now, because he knows this is a bad case. It shouldn't have been brought. And then they brought in Hank Brennan, who, again, shame on Hank Brennan. He's a defense attorney by trade. He should be saying, no, I don't want my name on this. And the fact that he's willing to take $350,000 and put his head in the sand speaks really poorly of him. Although for him, I think it's more of an ego thing as well. I think the whole thing is an ego thing for all of these people, because all these attorneys, because again, they get in the heat of battle and it just becomes about winning. It just becomes about showing the other one that that you can beat them. And that's what's definitely become abundantly clear in this case, is that there's a battle of ego going on in that courtroom. And, it's sad because there's a woman whose life right now is on the line. And, these lawyers battle it out and try to win. And this is the exact thing that when I started this channel, I said, the criminal justice system is not about winning and losing. It's about a fair process that adequately represents or that ensures that the defendant's rights and the victim's rights, and all parties to, because remember, there are two parties to this case. There's the O'Keefe family and there's Karen Reed, and John O'Keefe is represented by his survivors, people that, his mother, his father, and everyone that represents him in his estate. But he has a right to have a fair trial. And for, believe it or not, it doesn't benefit anyone to have John O'Keefe or to have this case being done the way it is. Because at the end of the day, if Higgins or if these people, and this is the thing that should upset people, is look, the Commonwealth had a chance to step back. They had a chance to reinvestigate this. They had a chance to go in, and again, I think Karen Reed said the flooring in that house, from that house, is in storage or something, and is available for investigators to investigate. But to me, if Karen Reed didn't do this, and John O'Keefe went in that house and got assaulted, that's an injustice, because that means that there's someone walking around who took this man's life, who beat him up, and that's not a win for anyone. It's not a win for anyone. So what we should be cheering for here is a fair process that allows for all the evidence to come in and all the evidence to be heard, and for a fair and impartial jury to evaluate that evidence, and nothing less. Because anything less is an injustice to John O'Keefe's memory. And right now, to have a judge like Bev Canoni on here, who's getting in the way of that, who's limiting the evidence that can come in, who's limiting the ability for the jury to explore whether or not, again, think about this. This jury was not allowed to hear some of the key evidence here that dealt with. Now, she left open the potential that they could raise Higgins and Alpert, but she wasn't going to let Colin Alpert be considered. And that's somebody who, again, remember, he had the marks on his hand. So she kept that out, and the state kept that out. If the state should not have been afraid, what the state should have done in this case, in my opinion, is called all those people to the witness stand to put it in front of the jury and let the jury consider it. And if the state is told that, yes, these people, the jury finds are not guilty, then that's essentially would be an indictment of the other side. Understand that if she's found not guilty in this case, okay, and she's only found guilty of OWI, that means there's more investigating to be done. Will the Commonwealth do what they're supposed to do in this case? Will they do the investigation to the best of their ability that they should have done in the first place? They fired the lead investigator in this case, and he was fired because of his actions in this case. So why have they not assigned a third party? Why have they not decided to team up with the Department of Justice and let them take an investigation, an investigative look into this thing? I mean, we have phones being destroyed. We have dogs being rehomed. We have houses being sold. We have, just unbelievable stuff that this jury was not even allowed to consider, really, in this case. The only thing they considered was the science of dog bites and whether or not the car data of Karen Reed's car showed that a collision occurred, which, again, it did not. Okay. Do recall that what Hank Brennan tried to rely on, and again, what you saw here was Hank Brennan using all of his tricks to try to get a conviction of Karen Reed. But there were 31 of those incidences, okay, that had occurred in the prior 6 months. So did she have 31 collisions? I don't think so. So what does that tell you? That tells you that is not proof beyond a reasonable doubt that the event that occurred had anything to do with the collision. It may have had to do with the fact that there was a snowstorm going on. It had to do with, and again, I think people are saying, well, why would she go to 75% throttle in the middle of a snowstorm? Well, have you ever been caught on ice? and she's intoxicated, she could have very well done that and spun the wheels to 75%. Doesn't mean that the car necessarily collided with anything. But proof beyond a reasonable doubt? No, not even close. But this is where you've got an experienced lawyer like Hank Brennan who's using his skills and using his craft for evil, for the wrong side of justice, because he's not letting the process work. He didn't put on a fair case. He was trying to win a case. But we have to remember that a win, and this is also something too that I think every day I watch Karen Reed walk out, every day I see her supporters cheering, every day I see, this whole thing going on. And I think to myself, while we're all watching from the comforts of our home or from the comforts of the sidewalk, and we're all going back, if she walks in that courtroom and a guilty verdict gets read, she's going to jail. She's going to prison. It's real life. Victory for Hank Brennan means she goes to prison for the rest of her life. Her whole life has been completely disrupted and torn apart. And when you think about that, and you think that that's happened because Hank Brennan wants to win, because egos collided, that's unacceptable. That's unacceptable, especially if the evidence doesn't rise to the level that of warranting a trial. Which, to me, when you look at this case, it's not. There's no way when you put the evidence before a jury, unless you're going to twist it, turn it, and misrepresent it. There's no way you get to a point to where you say a jury. Now, again, I understand jurors are finders of fact, and they can find anything facts. But what we're looking for is a fair process here. The investigation is flawed. The science is in dispute. We have phones that should have flown that didn't. We have taillight pieces that.
Morning. Good morning, everyone. You may be seated.
Oh, hold on, guys. I apologize.
All right. So before we bring our jury in today, a few things. One, I'm going to.
All right, give me just a moment here. I apologize. That was the. Give me one moment. That was the Valley trial, which we will talk about that as well. So go check that out. That's the trial we're covering here. The Preppy High School unaliving trial. If you haven't checked that out, it's extremely interesting. Young man is charged with knifing down 4 people. He's claiming self-defense. He's turned down multiple plea bargains. So far yesterday, by my account, his defense did very little, but he's got a very good defense attorney. But I think it's going to be a very difficult case to explain why you bring a knife to a fist fight. And this young man, I think, is going to be going away for a while. But this is the problem that, again, I believe bond should be something that every defendant should have the opportunity for. But it's also why when you're out on bond and somebody comes and offers you a plea bargain, it's tough to take that plea bargain when it involves a substantial amount of prison time, which in his case, it was 40 years. Now, in the state of Connecticut, he would have been potentially eligible to get out in about 24 years of the 40. So it was really about a 24-year sentence. And with him being, but for him, and you might think, wow, that still seems like a lot of time, and it does. But he's 40, in his 40s, he's getting out of prison. He still has quite a bit of life ahead of him, as opposed to if he's convicted, he's facing pretty much the rest of his life in prison. He's got 3 counts that he would be charged. Could get up to 20 years on each count. So he's looking at about 125 years in prison, which is essentially a life sentence. In Connecticut, unaliving gets 20 to 65, and then he's got to serve. Essentially, he's got to serve about 60% of that. So if he, it's a majority of his lifetime before he's eligible for parole. And if he gets convicted, I don't think he's going to probably get parole first time around. But by the time he does, he would be 70, 80 years old. So, but we'll see how this case goes. It's very interesting. So get over there and check it out. Well worth a watch. We're going to be rolling out additional coverage on it, additional videos and things. So it's going to be getting the full workup. But anyways, back to the Care to Read case. Bottom line is this case should not have been brought, and not in the form it's in right now, not with all the problems, not with Welcher, not with the disputed cell phone data and car data, and the fact that the state's own data, again, remember, when this trial began, they ended up with data that actually said, okay, he's this alleged event that was the collision that Hank Brennan's depending upon, and says this is the moment that that the car collided with John O'Keefe. John O'Keefe's still on his phone after that alleged collision happens. It's unexplainable. So what's he got to do? Well, he changes the report. I mean, it's egregious stuff that absolutely goes against the idea of a fair process here for Karen Reed. And that's why this case should never have been brought to a jury. And it should have been reinvestigated. It should have been put on hold. The charges should have been dismissed without prejudice and reserved for her to be charged later on. And they should have given a full investigation to this, brought in a whole new team, clean eyes, and completely reinvestigated this thing and said, okay, is there a way we can bring a case that meets the standards we needed to meet in order to charge somebody, in order to get this to a jury and prove beyond a reasonable doubt what exactly happened to John O'Keefe? And if it can't be proven, if it was so badly mishandled, so be it. Then we go address that issue. But you don't go and hire Hank Brennan for $350,000 to say, twist and turn the facts and get us a victory, because we don't want to admit our mistakes. It's not how it works. It's not how it should work. Let's put it that way. All right, we're going to go through a few more comments, and then we're going to wrap this up. Because like I said, I just wanted to come through here and give a little commentary on things. Go through some of these comments. So she wants to be the 13th juror. Looks like we are going to file a complaint against the judge in this case. Absolutely. And again, citizens can do that. We've all watched this. Worst judge I've heard, said Cecilia Picton. That was William Gage who said that. Cecilia Picton says, how on earth are the jury meant to remember all that? Cool Cucumber 710 says, the judge seems hell-bent on creating another mistrial. She's getting pressure from the higher-ups, and these idiots will try her again. Oh, they will. We're not going to go over the political comment there. What's that got to do with her being a drunk judge? This is the same problem from the first trial with the verdict sheet, and I was so confused with the judge reading it aloud. And then finally, my moose knuckle says, does anyone else suspect that the judge is under the influence sometimes during these trials? She fumbles and slurs her words at times. So I actually have suspected that. I wondered, because her pallor, sometimes she looks a little red in the face, thinking to myself, is she, maybe feeling the effects from the night before, the few glasses of wine she probably drinks when she gets home? Or is she somebody who's drinking on the job? I hope not. We would hope not. But I definitely believe she's getting pressure from the higher ups. I think she's doing the bidding of figures that are much higher on the food chain than she is, and she's, again, I told you, this is by design. That verdict slip is by design meant to prevent the jury of acquitting of everything but OWI and leaving the Commonwealth with OWI. Okay, that is what it's meant to prevent. Otherwise, she would have not guilty, not guilty, not guilty, not guilty. What she's saying is don't fill anything out until you've, again, because there's only guilty lines. The state doesn't, unfortunately, the state law doesn't prevent that from happening. And that's why they're getting away with it. So as she continues to lean back on Yannetti, who's the local counsel, and I believe Alessi is as well, but she leans back on Yannetti, and Yannetti reminds them and says, yeah, you're right. There's nothing. Have you found case law on it? No, there isn't, because there isn't case law, because guess what? It's allowed. And it's confusing. It's wrong, but it's there by design. And In addition, what she's going to try to do is she's going to definitely do everything she can. Now, the best thing that jury can do, I hope the juries have filled out the forms, the verdict forms, because what they need to do, and I hope that they have the common sense to do this, is fill out the two verdicts. If they've come to not guilties, fill them out and then turn them back into the judge. And unless she's going to destroy documents, someone on that jury needs to stand up and say, listen, we've come to a verdict on counts 1 and 3, if that's what they are. Count 2, we're deadlocked on. And let them get turned in. And then she will be forced to deliver the verdict on counts 1 and 3. There will be no way to get around that. The only way she doesn't get to deliver those verdicts is if she confuses the jury enough to think that they can't deliver a verdict unless all 3 verdict slips are filled out. And then they never tell anyone that they have the verdict or that they filled out the slips, or they never begin to fill out the slips. In other words, if it's something that, okay, we've moved past count 1, we've moved past count 3, but we're not to fill out anything. And if that question comes out, like, are we allowed to fill things out? That will be the ultimate showdown between the defense and the judge on how she responds to that question. And if she chooses to tell them they can't fill it out or something like that, then that will be tremendously egregious. And that's the type of mistake that could get her thrown off the case. But it doesn't necessarily mean that if she's successful in preventing them from delivering the verdict, then it doesn't mean that Karen Reed has to come back and do it again, just with a different judge. And maybe that will make all the difference. But as I've explained to you earlier, it doesn't change the burden that she's under and the extreme financial pressure she'll be under to try to bring back the defense team, which may or may not show back up. And maybe their egos will let them show up. But sometimes, the potential of financial ruin will outweigh any ego boost that you want to get by saying, I'm going to come in and beat this case because I just can't afford to do it anymore. And that's what the state tries to do. There have been scenarios. There was a case, I believe it was five mistrials, 5 hung juries, and they ended up getting a conviction after the 5th one or the 6th one. I can't remember the case off the top of my head, but the state, again, it's the one loophole that is completely unfair to defendants, because the state can just completely outrun you and completely wear you down and wear your finances down and leave you destitute to where you can't fight back anymore. And there's nothing besides getting appointed counsel, which is going to be far different than the hired counsel, or maybe the lawyer you've been paying all this money to do trials 1, 2, 3, and 4 might say, you know what, like Karen Reed's attorneys are doing, we're willing to do this pro bono. But again, if the attorney can't afford to do that anymore, they might need to go back to work, because right now these attorneys have been doing nothing but Karen Reed. They have to fly in from out of state. They have to stay here. And, it's a tremendous expense. And they're getting paid nothing beyond maybe expenses that they're able to collect from whatever funds that she's able to raise through her supporters. Anyways, so we'll see what happens. So I hope today we get a verdict. I think we will have a verdict today. That's my instinct. I think this jury is going to come back today. I think that it's going to happen probably around lunchtime. I think that, in my opinion, I think the way they're going to solve this is, I think that they're going to convict her of OWI. That's what I think is going to happen. I think that's going to be a resting place. That I think what's probably happened here is they've acquitted her of those other 2 charges. And then I think that the OWI charge is the thing that I think that will probably have more support in that jury room to say, listen, this is how we're going to have to settle this. They're going to convict her. And then I think it's going to be very interesting to see what Judge Canone does in terms of that conviction, because of how serious OWI is treated in Massachusetts. And we will see if she shows her ass and locks Karen Reed up, which is a potential outcome. because of the seriousness of it. And, you know, you want to see some angry defense attorneys? You wait till they have her locked up because she's been convicted of that, and we'll see what Bev does. Should Bev do that? No. But I think she's going to be so mad that she was acquitted of the most serious stuff that I think she'll probably do it. But I don't know. Maybe. Hopefully not. But that's what I think. Or I think that maybe the jury's back there. Maybe there's one or two that they're trying to wear down, and they say, you know what? Look, let's just quit. Like, if they've already acquitted her of 1 and 3, that's why I'm so surprised they went home yesterday. This lady's been through hell and back. She's financially ruined. Why are we sitting back there debating over this OWI charge, if that's what it is? Unless they're truly considering the manslaughter part, or one of the, maybe they're higher than that, but I think then you would think that, okay, if they're going to consider that an accident happened, although I think the way they would say they would get around the fleeing the scene is they would say she didn't know what happened, but that she could have struck him and not known, and they could be in that territory. I don't know. We'll see. But I think a verdict's coming today. I think they're close, and I think they're going to work out whatever it is that's going on here, and I think they're going to deliver. Like I said, I think this is a much more straightforward case in terms of how it was presented. I think I think a verdict's coming down. But if it doesn't, if they're confused, if they can't work out their differences on whatever charge they're hung up on, it's possible that this thing could break out into a really interesting event as the jury comes back and Bev Canoni tries to avoid having to deliver a verdict in this case. We'll see. Anyways, we'll be watching. I'll be watching. I'll be glad to put this case to bed. I think it deserves to be resolved. And it's been going on for way too long. And I think that the rightful way it should be resolved is I think it should be completely not guilty. I don't think you can trust any of it. I mean, listen, if you're back in that jury room, if there's a juror that listens to this, listen, in order to find her guilty of OWI, even though she admitted, okay, and this is something that everyone says, well, she admitted that she was drinking. That's not enough. Okay? It's not enough. I mean, it is, but it isn't. But it doesn't have to be. Like, if you want to settle it, it's not enough. And why isn't it enough? Because the law is clear. You need to show proof beyond a reasonable doubt that her blood alcohol level was above the legal limit. The only way you do that is through a breathalyzer or through blood results. Those are the only two ways you definitively do that. Now, you can also do a calculation that says, based on what she said, she would be at this. But still, again, she doesn't remember specifically. They didn't come in there and call the bartender and say that. They called some people and said, I think I saw her drinking X. I think I saw her drinking Y. Everybody's body metabolizes alcohol differently. The only way you know what it is if you get the blood test. The problem is, if you recall, the doctor that did the blood test said, by his own admission, that he wasn't certified. They were not, or credited or whatever, to do the blood test, to trust the results. And as a result, that alone right there says, okay, is that proof beyond a reasonable doubt? No, it's not. Okay? That's enough right there to just acquit her of everything and be done with this thing. And some might not like that. But the truth of the matter is that there's nothing about this case that you can trust. There's nothing about this case that was handled correctly. And if OWI is what they're truly struggling with in that jury room, look, resolve this thing. Resolve this thing. If that's all it is, then look, let it go. Okay? There is an argument to be made that the state felt that you can use to say you can't trust any of it. You can't trust the blood results. If you can't trust the blood results, then her words, of what she speculates on that she drank is not reliable enough to understand what her blood alcohol level results were at the moment she was driving. Now, many might say, well, she was driving and she'd had so much to drink. Well, you know what? She wasn't pulled over. Nobody took her blood alcohol level at that time. She says she had a few drinks. She says she wasn't drunk. We don't know what her blood alcohol level was. There's not proof beyond a reasonable doubt of what that blood alcohol level was. And it very clearly and specifically states in statute that it needs to be proven beyond a reasonable doubt that she was over 0.08. Well, if you don't have reliable blood results, you can't get there. Real easy, not guilty. Let's move on. Let's deliver 3 not guilty verdicts and move this case right out of the courtroom. So hopefully somebody back there is pointing that out and making that case. And then on top of that, anybody who thinks that you can prove a collision occurred with the evidence that they presented is just not looking at this case with clear eyes. Okay? Because there's too many unexplainable situations. Number one, the phone itself. Number two, why are the bones not broken? Why is there no sign? How do you explain why there was no damage done to his sweatshirt if he's allegedly, again, remember, he's allegedly getting the damage to his arm done by the taillight, but yet his sweatshirt isn't damaged. So how do you explain it? Look, again, now the jury's not considering all these other things, but there's the things we know about: the rehoming of the dog, the selling of the house, the destruction of the cell phones. I mean, these are the things we know about. The jury doesn't know that stuff. But when you put it all together, this is a case unfit to even think of sending someone to prison for the rest of their life on. So, anyways, with that said, guys, I'll leave you at that. We'll see what the jury does. We hope the jury does the right thing here and puts this thing to bed. We will find out, I think, today. If not today, I think, look, it's Wednesday. I cannot imagine this jury, with the notes they sent out yesterday, will make it past Friday. I don't think they will. But you never know. Hopefully, we get a result, though. And I hope the only result, in my opinion, in this case, with the way it's been presented, the only result that makes sense is not guilty of all charges. And that's my opinion. And I think that's where the jury's leaning based on their notes. And hopefully they get the rest of the way there and they bring over. Listen, I've been back there. I was a four person for a jury. We started out at 10-2 guilty of the most serious charges. And we ended up doing a compromise verdict of what ended up being equivalent of a misdemeanor. I didn't know it was a misdemeanor at the time. I kind of had the assumption, but I did not bring that up to anybody. But we swung back and we ended up going 11-1. And there was one person, one holdout, and I had to talk to that person. And we talked it through. And then that person said, fine, you know what? Let's go for it. So hopefully, though, if there's any holdouts or whoever's holding out on the other side of this thing will come to the idea, again, the overriding argument is you can't trust the blood. If you can't trust the blood, let it go. Let it go. Let it go. Anyways, with that said, guys, I'll be back, of course, once the verdict comes in. We will definitely do a talk. I will talk about my thoughts, and hopefully, too, now that I'm getting back into the groove of things, I will be reaching out and hopefully coordinating with the defense rest to come on and have a big discussion of this case. She's got a tremendous database of information, and I intend fully to hopefully get an opportunity to go on and have a big discussion and ask that database all types of questions and have some fun over there. So be on the lookout for that. In the meantime, guys, get over there while you're waiting. I'll put a link to the Karen Reed case in the I'll pin it to the chat. But get over there and check out the Raw Valley case. Okay. Again, this is the preppy high school murder unaliving case. got to check it out. It's very interesting. It's going to be going on probably the rest of this week. It's supposed to be going on for 2 weeks. I don't know if it's going to last 2 weeks. A lot of these trials, they say 2 weeks and it lasts, 5, 6, 7 days. But this is a case out of Connecticut, and it is extremely interesting. And he's alleged to have, well, he doesn't deny stabbing 4 people. The question is why he did it, and this is the type. These are the fun cases that really are up for debate. So get over there. We're going to be covering it. Get in there and start getting into the community polls. I'm going to be reviewing poll results on the Karen Reed case on a live here very soon. See what the community thinks. Get over to the community page. If you're not a member yet, guys, get on there and become a member, because you're going to get access to the members only toolkit, which includes exclusive background reports on these cases. It includes your toolkit, which includes recap summaries, legal summary or legal breakdowns of all the legal issues within the case, and a really cool thing to where I call it the dual narrative, where it takes the excerpt that we're dealing with and it frames it in the two stories, the state story and the defense's story, and it tells the story of two sides and what they're trying to accomplish. It's going to help you dig way deeper into the case, understand things, understand the legal issues, understand the case law. And these are things that I'll be using on air more as I'm on here talking, that we'll be going back and referring to. And then, of course, you want to get on and make your voice known to the community through our polls, because we've got a lot of polls that are going out on these cases that really break down key issues and key points. So get in there. These are things we're going to be talking about using. But most importantly, like I said, all members get access to the members toolkit at the first level of membership. So check it out, guys. It's really cool. And I'll be seeing you guys soon. I'll probably be in the Valley case today at some point to talk about that. So if you're over there, I'll see you over there. And of course, if a verdict comes down, you're more likely than not also see me back here talking about the verdict, giving you guys my thoughts and my 2 cents. With that said, guys, until we talk again, let justice prevail. I hope it does in this case, and I'll talk to you soon.
job. Come on, man. Good job. On the street. Back up. You get him off my cruiser. Good over there. Good. Thank you. Christina, send him on the ramp. Josh, come on in.
You are unmuted.
You see the court is in session.
All right. I appreciate you all getting back here. During the luncheon break, I received word from a court officer that the jury had knocked on the door, indicating that they had a verdict. But before I could even summons everybody into court, shortly thereafter, they knocked again and said they didn't have a verdict. So I asked the court officer to tell them to put that verdict slip in an envelope and seal it, and to give it to us. Paul, do you have it? Thank you. I haven't seen this. It's been sealed. I'm now going to seal it in the legal sense. So this is sealed. No one will have access to it. It will be preserved and made part of this record. I'm going to ask it to be marked for identification with the word jury, Chrissy, just to keep it separate and apart from everything else. So it's marked for ID with the word jury. All right. So we do not have a verdict because, as we all know, there is no verdict until it is announced and recorded in open court. So we are still awaiting a verdict. Because it took a while to pull this together, I would ask that everybody remain in the building until the end of the day. So we'll see everybody later.
Thank you. All right.
You are unmuted.
Will the deliberating jurors remain standing? Defendant remains standing. All other parties may be seated.
Your Honor, may the record reflect that 12 deliberating jurors and 6 alternates are present.
Yes.
May I inquire?
Yes.
Mr. Foreman, members of the jury, have you agreed upon a verdict?
Yes.
Thank you. May I see the papers? Mr. Foreman, have the verdicts just been placed in this envelope and have they been in your presence ever since?
Yes.
Mr. Foreman, on docket number 2282CR117001, murder in the second degree, what say you? Is the defendant at the bar guilty or not guilty?
Not guilty.
So say you, Mr. Foreman? So say you? No. Do you agree?
Yes.
Do all of you agree? Yes. Thank you. 002, what say you? Is the defendant at the bar not guilty or guilty?
Not guilty.
Of.
Is not guilty or guilty of that charge or any lesser included charge? Thank you. Specifically, number 5, operating under the influence of liquor by operating a motor vehicle with a blood alcohol level of 0.08 or greater. Correct?
Yes.
So say you, Mr. Foreman?
Guilty.
So say you all?
Yes.
003, what say you? Is the defendant at the bar leaving the scene after accident resulting in death? Is the defendant not guilty or guilty?
Not guilty.
So say you, Mr. Foreman?
Yes.
So say you all? Jurors, hearken your verdict as the court records that you upon your oath say the defendant on 001 is not guilty, on 002 is guilty of operating under the influence of liquor, and 003 not guilty. Thank you.
All right, jurors, everybody please be seated. Jurors, we thank you for your service. We're going to send you back. Your service is complete. I'd like to come back and talk to you for a little bit afterwards. So thank you very much.
All rise. Jurors, follow me.
Media, please exit the courtroom immediately.
Karen Reed?
Not yet.
Not yet.
Tony,
Hold
not
on,
yet.
hold on,
Not
everyone.
yet.
Karen Reed. Ms. Reed, can I have your attention? As required by statute, I must inform you that the records regarding the charges that you have been found not guilty will be sealed by the Commissioner of Probation by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want these records sealed. To request that these records not be sealed, you may use the Request Not to Seal form, which is posted on the trial court's website on mass.gov. I cannot accept the form here in court. You must submit it to the Commissioner of Probation at the address provided on the form. Please be aware that if the records regarding the charges which you have been found not guilty are sealed, you will be unable to access the sealed record of the not guilty dispositions or any other records regarding those charges. If you want copies of any documents regarding those charges before the records are sealed, you should request copies from the court within 10 days. Do you understand? Thank you.
All right, so we need a date for sentencing. Can we do it next week?
And we would be prepared to go forward today.
Okay.
Perhaps we can approach sidebar briefly.
Okay. All right, so Ms. Giannetti, you're ready to go forward today as well?
Yes, please.
Okay, Mr. Brennan, what's the Commonwealth's recommendation?
Your Honor, the Commonwealth moves for sentencing. We recommend Probation, 1 year, 24D program.
So the standard that everybody else gets on a first-time OUI?
Certainly.
Okay.
We ask that you be treated no differently, no better. No
So I'm happy to do it. All right. Thank you all.
1 year probation, 1 year probation on docket number 002, the lesser included offense of operating under the influence. 1 year probation. Thank you. The 24D program is. Thank you.
Immediately. All right.
Goodbye.